What's going on? Alex here, and I'd like to welcome you to a very special Efros Financial Power Hour. Last week, we talked about estate planning, which is all about controlling and protecting your assets. And while that may sound simple, accidents, lawsuits, personal and business relationships that go bad, changes in tax laws and other laws can take a very large estate and quickly turn it into a very small one. Fortunately, there are a number of strategies available and steps that you could take that will allow you to protect what you worked so hard to earn. And these strategies are typically referred to as asset protection. Our guest today is an accomplished attorney with over 40 years, you heard that right, of experience specializing in asset protection, estate planning, and litigation. He is a certified specialist in estate planning, trust, and probate law, and he's an expert in developing and implementing advanced planning strategies for business owners, key executives, investors, and high net worth individuals. Please welcome Keith Codron.
Thank you, Alex. A pleasure to be with you.
All right, pleasure to have you. Thank you so much for taking part in today's live stream. You heard my little preamble there. Did I basically more or less get it right?
You did. I specialize in advanced planning techniques, particularly for those with estates above the current exemption of $12 million, estate tax exemption. Those who wish to establish dynasty trusts for grandchildren and future generations. Those who are philanthropically inclined, for which I do charitable remainder trusts and lead trusts. Cuperts for estate freezes, grats also for estate freezes. And on the purely asset protection side, I set up trusts usually outside of California, which will own a limited liability company, can be in or out of California. And we like to separate the risk of owning multiple properties, let's say real estate, by putting them in separate LLCs, which are all owned by trusts in other states, sometimes overseas. I do foreign work also. And it's all designed really to shrink the bullseye on one's back as far as litigation exposure. A lot of people have, they'll say to me, well, I have a big umbrella policy or a lot of liability coverage. And I tell them that, first of all, when you need an insurance company, very often, because they have a lot of attorneys whose job it is to figure out how they shouldn't pay you, why they shouldn't pay you, because of some exclusion or exemption written into the fine print, a liability policy may not be the protection that you think it is. Also, a big fat liability policy will basically expand the bullseye on your back, whereas asset protection planning done in advance, and the farther back in advance relative to an incident occurring, the better, the stronger it is, that shrinks the bullseye. And we live in the most litigious state and the most litigious country in the world. So it is important to set up an asset protection structure if you're in a high exposure situation or think you may be, um, well in advance of when you're going to need it, and not on the eve of the jury coming in with a verdict, because then it's too late to start moving things around. Can't do it, and it would be undone anyway as a fraudulent transfer. So
Right.
yes, I do a lot of asset protection, which is a subset of advanced estate planning. I also do tax planning, and I am a certified specialist, as you said, in estate planning, probate, and trust law in California. But I should point out at the outset that everything I say tonight is not intended to be specific legal advice for a certain person or situation. It's intended as general information, and it doesn't establish any type of attorney-client relationship. Someone would have to call me, and then we would talk from there privately, and maybe a relationship would be started, maybe not. But I'm giving general information tonight. I'm not uh, giving specific advice for a specific situation. I want to make that very, very clear.
Understood, understood.
Okay.
And you mentioned a few terms there that I wanted to conceptualize for the people out there that have heard terms like limited liability, asset protection, and estate planning. How can we think about all of those terms? Are those living all under the umbrella of estate planning? Are they three separate areas? How can we conceptualize it to
Well,
people who are new to it?
okay, estate planning is a very broad term. That just has to do, estate planning means arranging one's affairs in such a way as to um, pass as much property to your intended beneficiaries as possible with as little red tape, taxes, probate fees, and other costs and expenses as possible. Everyone has an estate plan, whether they realize it or not. If one dies intestate, that means without a will, even, then the state of California has, as do most states, has an estate plan for you. But chances are you're not going to like the the estate plan that the state has for you, because there could be people coming into an inheritance from you who we often call laughing heirs that you never intended to share in what you've accumulated. So, at the very least, everyone should have a will, but a will does go through probate. And some people are confused about that. They think if they have a will that doesn't, then they will avoid probate. No, a will does get probated. In fact, the word probate means prove, and what's being proved is the will. It has to be offered up in a court proceeding. A living trust, if it's drafted properly, should be able to avoid the court supervised probate system. Uh, but even so, a trust without tax planning provisions is not going to help as far as saving death taxes or generation skipping transfer taxes. So when I do estate planning, I I usually separate, and I'm not talking about asset protection per se, but estate planning where there's going to be at least a revocable trust involved. I separate the clientele into those who are likely to be above the $12 million exemption and those below. Now, having said that, the $12 million, actually it's 12 million and 60,000, okay, because of cost of living adjustments.
What's 60,000 between friends? I always say.
Exactly. And in on January 1, 2026, and that's if the law stays the way it is now, that exemption will go down to 5 million plus a COLA, cost of living adjustment, which will probably, we think, mean that the exemption will be around 6 million adjusted. So that's $6 million of wealth that one can pass to one's descendants, because there's an unlimited marital deduction for what you give to your spouse. If the spouse is a U.S. citizen, I never assume that's the case. Many times I've had a spouse who's a Canadian citizen but not a U.S. citizen, and that makes all the difference, uh, because there's not an unlimited marital deduction if the surviving spouse, be it husband or wife, is not a U.S. citizen. But let's say a widower wants to leave wealth to their children, which is typically the case. Right now, they could leave up to $12,060,000 without any death tax.
So just to touch on the just the framing, if we were just to look at a
Yep.
30,000-foot view, estate planning is the broad topic, and then within that we have asset protection, and one element of asset protection is limited liability. Do I have that right?
Yes.
Okay.
And other subsets of estate planning would be business continuation, business succession, and income tax planning. In recent years, because the transfer tax or estate tax exemption was so high for most middle class families, people were more concerned actually with the step up in basis for income tax purposes than they were with being in the estate tax, at the estate tax level. Let's put it that way.
Okay. And in terms of limited liability,
Okay.
I'm sure a lot of people have heard the term, but I get the sense that there are many misconceptions of what it encompasses and what it doesn't encompass. Can you delve into limited liability a bit and explain exactly what that can mean, and does it mean different things in different contexts?
Sure. And first, I should point out that a revocable living trust does not, again, it's designed to avoid the probate system, but does not provide any limited liability. There's no asset protection for a revocable trust, only for irrevocable trusts, and then they have to be drafted correctly. So let's talk about a limited liability company, which is probably the most popular form of holding title to rental real estate in
Also
California.
known as LLC, right? Your typical,
LLC, yes,
yeah.
and it's a creature of statute, which means that you you have to form it under the laws of a state. Um, Generally, if it's real estate that's located in California, then I will use a California as the organizing state for that LLC. If we're talking about non-real estate assets, accounts of some kind, then I would usually form that LLC in another state, which is more business friendly. I'll put it that way. But limited liability, just
So what you said there, just to highlight,
yeah,
it is for purposes of convenience. If the property is in California, you'll use a California-based LLC or LLC formed within the state. But if you could stay out of California, you stay out of California. It sounds like, correct?
right, right. And
Okay.
also, if it's a business that's being run in California, then I use the California as the organizing state. What I use outside of California are investment account LLCs. Okay.
Okay.
And a I have found that if a person sets up a single member LLC, while that may be convenient for tax purposes because it can be disregarded as a separate tax entity, it has very little, if any, value for asset protection to set up a single member LLC. And even husband and wife, if they're the only members, it's very weak. In California, we have cases that have held that where a member of an LLC has debts, the creditor can reach in to the LLC and attach assets.
Okay.
People
And
don't
that's a
realize
concept
that.
that kind of blows my mind. And I wanted to
Yeah.
circle back to it because before the stream, you talked about not only you have to worry about downstream liability from the business entity to
Right.
your personal assets, but what I'd refer to as upstream liability as well
Well, actually,
from your
there's a name.
personal side.
There is a name for it. It's called inverse veil piercing. We learn in law school that with a corporation or LLC, there's a veil that can't be pierced. Here we're talking about the veil being pierced the other way, where it's not the business debts that would spill over to cause personal liability, but where there's pre-existing personal liability, having the debts of the business that are in an LLC or corporation be attached to satisfy an individual member's obligation.
Let's
That's
expand
what's
the aperture if we
scary.
could, right, on the LLC side, because you mentioned that even though you have this limited liability entity, and let's say that the person doesn't forget to retitle their property to it, what sort of protection does it actually offer, if any,
Well,
as
if it's
opposed to holding the property in your personal name?
okay, if it is a multi-member LLC, and if one of those members is an irrevocable trust located outside of California, that means, let's say, a Nevada trust has a Nevada trust company acting as the trustee, and it is the trust instrument provides that Nevada law will apply. There are accounts that are set up in Nevada. It's, for all intents and purposes, a Nevada entity owning a significant portion of the total membership interest of the LLC. That will go a long way towards protecting the patriarch or matriarch of the family. And generally, if you have your children own at least a 1% membership interest in the LLC, that will help too. So very often I'll set up, let's say there's a rental property involved. The property goes into an LLC, which would be owned 1% by dad, 1% by mom, 1% by each of the three children, and then 95% by a Nevada or South Dakota trust or Delaware trust. But I specifically like South Dakota and Nevada to own 95%. And of those irrevocable trusts, the family members would have discretionary interests. That is, the trustee could make discretionary payments or not.
So it sounds like
Once a
you're adding.
trustee, I should say, must make payments to, let's say, dad, then a creditor can get whatever can attach whatever is required to be paid out to that member.
So
That's
just
why I
to
make it
put an
discretionary.
example on this concept,
Okay.
let's say you have a rental property in California, a real estate owner within the state formed the LLC, retitled the property to the LLC. Somebody's in the bathtub on the second floor, it falls through the floor, they're injured, and they start suing everyone. How can that play out if you just have the standard LLC in place? Let's say it's a single member.
Okay. Well,
How can that play out?
what you've just described is a liability that arises from within the LLC, right? You said
Right.
if there's an injury in the on the premises of the real property that's owned by the LLC, then whatever assets are owned by that LLC are subject to pay a judgment. If the LLC is structured properly, then the personal assets of the individual members should not be at risk. But what I was talking about before is where um, a one of the family members incurs liability individually outside of that property, and a creditor wants to attach the real estate that's inside the LLC to satisfy a member's uh, a judgment against a particular member. Okay.
Okay.
And that's why I like to have an out of state trust own the lion's share of membership interests of the California LLC, because the irrevocable trust in the outside of California is not itself going to have any liability of its own.
Right. And then touching on the concept of owning real estate within a limited liability company, I've seen many cases on the tax side where an owner of properties will have 10 different LLCs and one property in each LLC. Is that a prudent move in terms of limiting the liability that may
Yes,
arise in one LLC and prevent that judgment from attaching
right.
assets in one of the others, even if it's all owned by the same person?
Exactly. Think of a pool table with separate pockets, separate holes. We want to, for each piece of real estate, rental real estate, or let's call it investment real estate, that gives rise to liability, which they all do. We don't want the liability from one piece of property to taint the others. So by putting them under separate roofs or separate LLC, and we can have the same Nevada trust own, say, a 95% interest in all those LLCs, whether it's 3 of them or 30 of them, um, that provides for much more protection, because then the worst that can happen is the assets of the LLC, which had uh, which owns the property where the injury occurred, for example, only those assets will be at risk and not any of the others.
And that's if you structure it in the way that you discussed with the Nevada trust and so forth. If this is just
Right.
a single member LLC with just that plain structure, there's a problem there, right? If someone owns 10
Absolutely.
single member LLCs.
Yes. A single member LLC might be convenient for taxes, has very little, if any, in my opinion, asset protection value. So it depends what a person's strategy, what is their goal. But if it's asset protection, a single member LLC, although allowed by statute, is almost worthless, I would say, especially in California.
Which I think would surprise a lot of people because
Right.
as soon as they get their first rental property, they throw it in the LLC and they think they're all done. Can you talk a bit about
Oh,
how
let me
insurance?
say one more thing,
Yeah.
Alex, while we're on LLC. Um, the manager of the LLC does not have to be a member of the LLC. So let's say dad is already successful, doesn't need the income flow really from the LLC at all, and just has his 4 children and the trust be the members. But he can still be the sole manager of that and make all the decisions, control the checkbook, and if need be, even dissolve the LLC if the operating agreement allows for it, to downstream the assets to a safer locale, shall we say.
So what you're saying is you can separate the control and the liability aspects of
Right.
owning that entity.
You can separate the management from the ownership. And by the way,
Okay.
the very key to asset protection is to separate ownership from control, because what you control but don't own can't be taken from you. No one can ever confiscate Well, I mean, if let's say in this case, dad is the manager but doesn't own any membership interest directly in that LLC, even if he were sued for something unrelated to the LLC, there's nothing uh, of his that he owns with regard to the LLC that could be taken because he's a manager. He's like an employee in a way.
And it looks that way on paper, so in form, but in substance, some would argue that that's not really the case, that he's really in charge, he's calling the shots. So
Oh
can a
no, he is.
court
No,
pull
he
that
really.
apart?
No, he most. There's nothing. And by the way, any asset protection strategy which relies on not being completely truthful or trying to hide the true nature of things will never work. It has to stand on its own, or it's no good. So, no question about it. The manager has, unless the operating agreement says otherwise, has full control over how that entity is going to be run. He or she just doesn't own an interest in it, an equity interest, but can take compensation per the operating agreement. Think of the operating agreement as a shareholders agreement in a corporation, or a partnership agreement in a limited partnership. Um, Nice thing about uh, an LLC over a family limited or over a limited partnership in general is that with a limited partnership, you must have at least one general partner. So
Right.
the general partner has liability. That's why often you see corporate general partners. So that adds yet another layer uh, to create. A corporation just to serve as general partner of a limited partnership. But with an LLC, you don't have that extra layer if you don't want to.
So to achieve the goal of asset protection in this context, the relationship of the owner and manager has to be bona fide, right? It can't just be on paper, but in reality, they're doing something else.
Well, it's all set forth in a written document.
Got it.
Absolutely, which is basically a contract between the owners amongst themselves and between the owners and the manager.
Got
And the
it. Got it.
manager doesn't have to be related um, to the members at all. When I say members, think of partners, if that helps. But the manager could be a corporation, could have a corporation manage um, LLCs, each of which has different investment real estate in it. That's perfectly okay. Or it could be one of the family members. I'm just saying a manager can take compensation, but doesn't get a distribution as such. Very often, a manager may also have a membership interest and can take a distribution along with all the other members of their prorated share of the profits. But as a manager, they get compensated.
Got it. Got it. And there's a common perception out there that you can achieve asset protection through insurance. So, can you talk a bit about how that works and how insurance fits in within the context of asset protection? Are they two separate things or can they work in conjunction?
Well, there is an exemption of the loan value of cash value insurance, permanent insurance in California, of it's about $13,000. Not that much really, but that's of what's called the loan value, which think of it as it's similar to cash surrender value. Uh, the idea is that no one can take the policy away from you, but they can just force you to disgorge most of the accumulated value inside that contract. Now, if it's a term policy which has no cash value, there's nothing for a creditor to take.
So, you're referring to life insurance in this
We're talking about life
context.
insurance.
So, if
Are
we,
you talking about liability insurance?
right.
Oh, well, like I said, liability insurance makes you a much more attractive. This gets back to the bullseye word picture. The bigger the liability insurance policy, the more attractive you are to a plaintiff's lawyer because you've got an insurance company in back of you. So you just have increased your financial profile. It's like saying, here I am. I got this big policy in back of me. Whereas asset protection planning works in just the opposite direction. We want to shrink the bullseye. We want to uh, make you have as small a profile financially as possible. And again, that's by separating control from ownership, because what you control but don't own can't be taken from you. Um, so they're actually they're not at all alike. Insurance, and I'm not saying that someone should drop their E&O policy or their umbrella policy, but just remember that when you look to an insurance company to pay the claim, very often they will look for excuses why your situation falls within one of their 10 pages or 20 pages of fine print exclusions.
Right.
Because it always starts out, yeah, we will cover you, and then that's the general rule. Okay, and then pages and pages and pages of, oh yeah, but we didn't really mean what we said on page one.
Because every dollar that they don't pay out on your claim is a dollar
More
of
profit
profit.
for right.
And can you talk a bit about some of the situations where insurance has refused to pay that you've seen? Because there is the concept that, oh, I have insurance, I'm good, but that's not the end of it. That's just the beginning, right?
Oh, sure. Well, I'll give you a very personal example. I happen to live on a street which you may have heard of the coastal fires in South Orange County. That happened. It was May 11th, a date that will live in infamy here in Laguna Niguel, where I live, and 20 homes on my street burned to the ground. Okay. We suffered some damage, but at least still have a house. But the homeowners on my street are just going through a very difficult time with their insurance carriers. And I won't name them, but we all know the popular names of homeowners insurance carriers. Um, and it's because uh, always buried in the fine print of the liability insurance contracts are reasons why their their liability is limited. Oh, they don't have to pay what you think they are, or you're going to get some lesser amount uh, than what it takes you really to be made whole. So relying on an insurance carrier, um, while again, I'm not advising anyone to cancel their liability insurance or umbrella, but I'm just saying they may not be there when you need them. Whereas if you have a solid asset protection plan in place well before an incident occurs where you need to pull the trigger, that's no one is going to be denying you of some claim that you're entitled to.
And there's also the issue of the limits on the policy as well,
True,
correct? If your
true, true.
policy will cover up to 250,000, but you just have $1 million judgment, then that's not
Right.
going to get you there.
Right, and the person a person who plays by all the rules think, oh, I'm never going to get sued. If let's say they have teenage driver, okay, who's driving a vehicle that's registered in the name of mom and dad, and the uh, the teenager gets to an accident for which they are at fault, and they kill a brain surgeon, and there's a judgment way above policy limits. Well, the creditor and the lawyer uh, for that judgment creditor is going to look to the deep pocket, and the one who owns the register, who owns that vehicle, or to who's to whom that vehicle is registered, and that's where a lot of liability can come into play.
Gotcha, gotcha. So in that case, going back to the structure you spoke about with the trust in Nevada, that's going to help mitigate some of the potential liability from such a situation, correct? If
Yes.
it's in the context of the LLC or a business.
Right. And for an extra level of bulletproofing, also we go overseas to the Cook Islands, and we can go to Bahamas, Panama, Isle of Man to set up foreign trusts. And that's an extra level of protection because U.S. court judgments won't be honored there. But this all has to be set up long in advance so as to avoid any type of fraudulent transfer action.
Talk a bit more about that because I like tropical places. So any excuse to get out to where it's sunny, I'll take it. But that does offer additional protections as
It
compared
does.
to
It
owning
also, it
assets in the
also,
US,
though,
right?
to be fair, it also involves more expense whenever you're going overseas. There's more, uh, more paperwork, more tax forms to file, and you must disclose everything. It is certainly not illegal to have your money overseas, but the IRS wants to know where it is because they want to make sure that you're reporting any and all income from it. and of course that's what we do. I never, if someone comes to me and says they want to hide something, and as soon as I hear the word hide, then I have to hang up the phone, because that's not something I would get involved with. But as long as everything is disclosed, and the income is paid. By the way, asset protection strategies are designed to be tax neutral, not to cost you more taxes, but they won't save you taxes. There are so many other strategies to save taxes, which are not necessarily for asset protection purposes, but to save taxes. And of course, a charitable remainder trust is the first thing that comes to mind, and an irrevocable life insurance trust, which we haven't talked about yet.
So, to frame this a bit more, I think it would be good to just look at an example, just so we can conceptualize this a bit more. And let's say we have two individuals, let's call them good partner and evil partner, GE, right? And they start a business where they start creating snack bars and just selling them to customers. And let's say they didn't put any business entity in place. They just started this in their basement and it turned out to be successful. And evil partner, without the knowledge of good partner, just so happened to start selling product with a known allergen in it. And there's a judgment for $1 million against this
Okay. Well, what you've described is,
relationship.
is a general partnership. So all the general partners are liable for all the debts and torts, as we call it. Tort is a civil wrong. It's the civil analog of a crime. Okay. Not that anyone's going to jail, but there can be, a big judgment to pay. So all general partners are liable for the debts and wrongs or torts of any other partner.
So if evil partner booked it to the Caymans, good partner
And
is
evil and
potentially
evil and evil
liable.
evil partner goes BK, files bankruptcy, so that nothing is collectible from evil partner. Then general partner is left holding the bag,
For
and
all of it, potentially,
for
not
all of it,
just half of it.
absolutely for all of it.
Okay.
And the same situation applies where people own property as tenants in common. Two couples, I've seen this a lot in my 40s. Two couples, they've gone on vacation together and they decide, oh, we really love this particular spot. Let's invest in a mountain cabin together. Okay. So they don't form any type of entity. It's just four people on a deed. And if one of those people has any type of liability from something having nothing to do with a piece of property, that piece of property then can be sold out from under the group. Now, the people who were not liable, they will get uh, their share, what's left of it after a sale, but the property is gone.
Got it. So in that case, let's say it's four tenants in common, 25% apiece. There's a judgment against one of them. The other three, let's say good tenants in
They're
this
going to lose
case.
the property so that the one party who has the judgment has uh, to pay out of their share. Well, to
Got it.
pay cash, then the whole property has to be sold. The other partners still get their pro rata share, but or as I say, what's left of it after a fire sale. But it's just not a good idea to own, especially to own real property, or any kind of business operation uh, outside of a structure. And
Okay.
tenants
So
in common, there's no structure.
so how would you advise that client in this case to structure that ownership of that property as
Well,
opposed to the four tenants in common?
it might be a C corporation. It might be an S. Well, if it's real estate, rarely would I advise them to incorporate that. But if it's a business, it might be a CRS, uh, but also LLC or limited partnership. But with limited partnership, again, you have to have a general partner. So unless you want to have a corporation be the general partner, or somebody wants to take that liability, LLCs usually win out a, as a preferred structure over most limited partnerships.
So
Uh,
let's play that scenario out
but
differently with
sometimes, I
good.
should say,
Yep.
sometimes strictly in the family context, where let's say dad wants a lot of control and still wants to own a piece of the pie, and where the partnership is just going to own investment assets, passive, an account or one or more accounts, as opposed to an asset like real estate that gives rise to liability. That might be structured. That might be something to structure as a family limited partnership.
Okay. And if we go back to the example of good and evil partner in that case, since they didn't form any entity, they're seen as having a general partnership, whether they knew it or not. And in
Right.
many cases, I would imagine that good partner had no idea that they're liable for this much in terms of what can happen if there's a judgment. Let's reframe that and now consider that they started a multi-member LLC. Same scenario, evil partner, judgment for $1 million, disappears or declares bankruptcy. What happens to good partner in that case?
Okay. If it's just the two of them and one partner's interest is foreclosed on to satisfy that partner's obligations, the assets in the entity may not be attached, but then the good partner becomes in essence, a receiver to pay out the creditor out of the bad partner's share, and that can destroy the entity right there, because who wants to do that? Basically, be just a paymaster for a creditor of one's ex member or partner, that had their membership interest foreclosed on, or had a charging order. A charging order is a lien on distributions. In
Got it.
California, though, when that remedy, and that's an equitable remedy, that a judge would impose, if the judgment creditor is not getting satisfaction from the lien on distributions by way of a charging order, that's when a judge, and they do in California, can order the evil partners, let's say the judgment debtor partners, interest to be foreclosed on.
Got it. So it's just 50% in that case, not the
Yeah,
entire million that the good partner
exactly,
would be subject, would
exactly,
be liable
exactly,
for. Okay. So
exactly.
that's a huge benefit right there, in terms of 50-50 as opposed to the whole thing. So that highlights the importance of putting that business entity together and not
Right.
just doing it as a general partnership.
Now
How could,
let me talk about one other thing briefly,
yeah,
because while I'm thinking about it, we talked about drop if one owns several pieces of real property, that from an asset protection standpoint, the best way, and let's say it's California real property, the best protection is to drop each property into a separate LLC. Okay, and have
okay,
it can be managed by the same person. You can have that Nevada trust own 95% of each of those LLCs, but they're separate structures. However, each structure, if it's an LLC, is going to trigger the $800 minimum tax every year.
right.
So if
And you're
someone
referring to the $800 annual tax at the California level
at the
per
California
any
level,
LLC, essentially,
that's right.
that even if it doesn't make any money, just the fact that it exists costs 800 a year, correct?
That's right. You could be losing your shirt, but you got to pay the franchise tax board $800 a year if it is a California LLC. Not so if it's out of state. But if it's out of state and you're doing business in California, they will catch up to you and fine you. Plus, you'll have to pay the $800. That's why, if a business is being run in California or the real estate is in California, I set up the LLC in California, because there is no way to get around that $800 tax. But what I was going to say is that if someone says, "Well, I'd like to put this in I own 10 properties, I've been a successful real estate, but I want to drop them all into separate, but that means 8 grand a year just in franchise tax or the LLC tax." So, can we um, reach a balance? Yeah, we could put them into five. It's just that, again, any two more properties in the same under the same LLC roof, liability that originates from one will taint the other if it's in the same LLC. But there's a lower LLC tax, so there's a balancing there. I see we have just a couple of questions. Should I answer one of them?
Yeah, if you would like. We
It
have
says,
some.
why Nevada or South Dakota, not California? Because California is the least business-friendly state in the country, and does not allow self-settled trusts for asset protection purposes.
What does that mean? A
Yeah,
self-settled trust?
self-settled trust means that the settlor of the trust is also a beneficiary. Now, there's nothing illegal about this. In fact, most revocable trusts are self-settled trusts, but they afford no asset protection whatsoever in California.
So just to be
However, in
clear, the
Nevada or
settlor.
South Dakota, they do because they have different statutes.
Got it. So just to be clear, the settlor is the person who created the trust, who put the assets into the trust.
Right.
And if the beneficiary is that same person, California looks at that and goes, there's not really much there. It's
Right.
basically one and the same, right?
The term settlor and trustor are interchangeable.
Got
I
it.
use the word settlor because our state probate code uses the word settlor. If they use trustor, then I would use trustor. But basically, a trust is a three-party contract. There's a settlor, a trustee, and a beneficiary. What is a trust? It's not an entity. People refer to it as if it was. It's not. It's a relationship. It's a particular type of it. It's a fiduciary relationship whereby one party agrees to hold, invest, and distribute property on behalf of another.
Got it.
Okay.
So
For the
going back,
benefit of someone else.
understood. So going back to the example with good partner and evil partner, let's consider that for a second. They put
Or how
together.
about even not good and evil, but high risk, low risk? Because they don't have
Okay.
to be. They don't have to be evil to get into, lawsuit hell.
Okay. Fair enough. So let's do that. So we have high risk shareholder and low risk shareholder. Now, in this case, same situation, but they put together a corporation before this all went down. Does that help their situation at all?
Well, from the asset protection standpoint, uh, they will also be protected, but the corporations, unless it's an S corporation, they're going to have the double taxation, right? The corporation pays tax at its level, and then when it declares a dividend to the shareholders, there's another tax. LLCs, like partnerships, are conduit or pass-through entities, so you avoid the double tax.
All right. We have a question here from Hunter, and he asks, is a land trust just a trust where the trust property is land? Or is there some sort of special pros and cons of a land trust?
Now, I don't deal with land trusts at all. Those are popular, I know, in Illinois, Massachusetts, but in California, we don't have land trust statutes per se, so I don't even get involved with those. But raw land can certainly be owned in a trust. The problem with owning land in a trust is that since it doesn't produce any income, but you still have to pay estate tax on it when you die, if you're over the exemption, it creates a problem. Anything which does not generate cash flow it's not a good asset, I would say, to keep within a trust portfolio. But sometimes people inherit land and thinking that, well, they're going to build on it in their retirement. I've never seen that happen once, where they actually all it does is they pay property taxes for years, and but there's no California land trust per se. Let's put it that way. So I don't even deal with land trusts. One other type of trust I don't deal with, and I deal with just about everything. I don't deal with pet trusts. Now, we do have pet trust statutes, and there are some people who, but rarely do I ever even get a phone call for someone who wants to set up a trust for their pet. But a lot of charitable trusts I do. But
Are you saying that I cannot set up a trust for my poodle
no,
Fluffles?
you can, and that has its own set of statutes. I just don't get involved in that. I have enough on my plate, so I don't do pet trusts.
Okay, so
But
any
I know
poodles
that.
watching, don't
Yeah.
call Keith. But any people who want to establish a trust, definitely give Keith a call.
I think Leona Helmsley set up a $12 million trust for her cat in New York, and I don't know how that worked out for the cat, but but I don't get involved with that. Let's see.
Now that we touched on pets, I'd like to touch on another potentially sensitive topic. Not that I'm
Okay.
going to ever have to worry about this the way my dating life is going, but can you talk a bit about how asset protection works within the context of prenuptial agreements.
Oh, sure. Well, prenuptial agreement is very important, first of all, that each side be represented by independent counsel. Otherwise, they won't be worth the paper they're written on, because it's assumed that if one party has legal representation and the other, let's say prospective spouse, does not, that the former is taking advantage of the latter. So always want each um, would-be spouse to be represented by their own lawyer, who then has to sign off on the prenup as to the form and content of it, to show that neither spouse was being taken advantage of. But if it's drafted properly, it certainly is a very useful tool in second, third, fourth marriages. I have had clients who are on their fourth, so that's where a prenup is extremely important. If both spouses will agree to it, because that can transmute, which means change the character of what would otherwise be community property into separate property, which is usually what people who are on their third or fourth marriage want. They may be okay with a small amount of their assets being community, but the lion's share of it has been accumulated before the marriage, so they want to keep that sole and separate, including earnings and retirement accounts. Very important. So that's where a prenup will lock down the non-community property status of those assets, so that um, someone who let's say there's very unequal wealth levels of two people who are in their 70s and they get married. Okay, the probably the children of the spouse who is just getting married now for the fourth time wants to make sure that if the new spouse of their, let's say of their father, could be the other way around too, survives their father, that spouse doesn't walk away with the bulk of the estate. So they may insist that dad get a prenup before um, entering into the marriage.
Yeah, and on that, Maria asks a good question. So if one side in a prenuptial agreement has legal representation, the other one does not, it can effectively invalidate the prenup altogether,
Well,
correct?
it's not void, as we say, void ab initio, which means just null and void from inception, but it is much more likely to be subject to attack by uh, the the party who feels aggrieved. So that is more likely to lead to litigation if one later on, when when the parties are actually, or their kids are really looking at this prenup, uh, after a death or after a dissolution of marriage, it's much more likely to lead to protracted litigation than if each side was represented by counsel from the get-go and their lawyers signed off as to form and content. That is very, very important.
Got it. So every side needs legal representation, adequate time to review the provisions, and so forth. That all makes sense.
Right.
And with
Can I answer?
California, yeah.
Go. I was going to answer another one because I see the questions are mounting up, and I didn't
Okay,
want
yeah, you're getting
to.
a lot of questions. This is
Yeah.
good.
But
All right.
is there a benefit? This is from Maria.
All right.
Is there a benefit to having an irrevocable trust versus a revocable one, or the other way around? Well, they serve different purposes. A revocable trust is a will substitute. It's an improvement on a will. So that is pure estate planning designed to avoid the whole probate or court supervised death system. Let's put it that way. But a revocable trust does not have any asset protection, not in California, for the settlor or trustor of that trust. None. An irrevocable trust can have that protection and often does. And if it's set up outside California, usually it'd be much more protective than it's set up in California. But even if it's in California and the object is not asset protection, an irrevocable trust, irrevocable, is designed to save taxes of some sort, whereas a revocable trust doesn't save taxes. Um, Best a revocable trust can do in the form of taxes is just to make sure that property that's held in the trust is community property instead of joint tenancy, so that there's a full step up in basis when the first spouse dies. But to answer Maria's question, the benefit to an irrevocable trust is tax planning or tax minimization, and in many cases, asset protection. That's why I say I like to have an irrevocable trust out of state own the lion's share of an in-state LLC if it's California real property that we're talking about.
Got it.
Um,
Maria, thank you for your question. Great question.
okay.
While we're on the topic of irrevocable trusts, one situation that I saw when I was working as an investment advisor is there was an individual and they got in a car accident. And unfortunately, there were injuries or someone unfortunately passed away. And there was a judgment. But before all that happened, as soon as the accident occurred, this person took all of their assets, dumped it into a newly formed irrevocable trust with their mother as the trustee. And the idea was that they can wipe their hands of the liability and still hold on to their assets in this kind of roundabout way. Is that something that would hold up, or
No,
would a court pull that apart immediately and see it for the substance that's there?
the other side would ask the judge to cancel the instruments. In other words, if the transfer was made by way of a deed, the deed would simply be canceled, as if nullified, as if it never existed. The trust could be canceled. The judge would completely rescind that transaction as a fraud upon the creditor, and probably impose some type of penalty on the person who tried to get away with paying their debts. But like I say, when asset protection is done well in advance before there are any creditors on the horizon, then it's much more solid, and all the T's have to be crossed and the I's dotted as far as the different structures, the trust, the LLCs, corporations. You can have a whole myriad of things, onshore, offshore, but it all has to be, and it has to have some type of business purpose, not just to trying to avoid one's just debts. So the more business purpose you have, the much stronger the asset protection structure is. Let me see if there's another question. I think I answered about why Nevada, South Dakota, they are much more business friendly.
Yeah.
Um,
And I was going to
some.
touch on the questions in a second. If I could
Oh, okay.
just touch on no, might have to touch on a question here. Let's see.
I thought there was a question about the exemption before, but I
Yes,
didn't.
yes. So
So anyway,
that's
oh, did I just?
thoughts on the estate tax lifetime credit going down from $10 million.
Okay. Oh, there I am. Um, well, it's not 10 million. Right now it's 12.06. $12,060,000 is what each of us can transfer, assuming we've made no taxable gifts during our lifetime, to our, let's say, our kids. Okay. Um, and the the way the law is now, that is going to sunset. That high exemption is going to sunset automatically um, on January 1, 2026, to 5 million adjusted for inflation. Well, we've had pretty hyperinflation now. So I would guess that'll come down to about 6 million from the current 12. So it'll be halved.
So what you're
Um,
saying is just
and
to
that's if Congress doesn't change the law. But because the federal estate tax is so politically charged, the whole 99% versus the 1% and all, politicians love to talk about that. Then if Congress changes that exemption, then who knows? They could bring it down to 3 million. When I first started years ago, it was well below 600,000, the exemption. In fact, I think it was 100 and I want to say like 187,000 or something. But that was 40 years ago. Okay, and it's creeped up. But and the annual exclusion on gifts was 3,000. Now it's 16,000, and I think it's going to be going up to 17. It all depends again on the COLA, cost of living adjustments. But um, and one can give any amount to their spouse if the spouse is a U.S. citizen. Not U.S. Here's where having green card, permanent resident, that's not enough. There's no unlimited marital deduction, as we call it, for transfers from a decedent to a surviving spouse who is not a U.S. citizen. One of the first things I ask on my intake forms is, are you a U.S. citizen?
Okay, because that could dramatically change the income tax implications of whatever plans you're putting
That
together,
would
and also,
change the whole structure of the trust that I draft. The entire, you know, it could be a beautiful trust, but if it doesn't take into account that, it's dangerous. That's why you have to go to a lawyer who knows what they're doing and knows the questions to ask and doesn't make any assumptions.
now, on that point, there are a lot of business owners out there that form their LLCs and corporations, what have you, using templated documents or services that'll just crank out boilerplate LLC operating agreement. And obviously, there are some pros and cons associated with that. Can you speak to some of the complications that arise when one uses a templated document to form their limited liability entity?
Well, a template document is only as good as the questions that the layman knows to ask. Um, and also, when things go wrong, as they inevitably will in a business, who from, I won't name the company, but the software maker, are they going to send someone to represent you in court, whether it's civil or probate division, to clean up the mess because you didn't know to ask certain questions, so the software spit out an answer that is completely inappropriate for your situation? So I love when people get their $69 whatever, you know, trust LLC, because I know that they'll come to see me or someone like me down the road, and it's going to be much more expensive when we're in court. Litigation um, easily gets into the six figures within the first year. I mean, and if it goes all the way to trial and appeal, it can be hundreds of thousands of dollars, even for relatively simple disputes. And I've seen disputes like between siblings. One sibling thought they were entitled to more than the other, and there's so much emotional baggage, and the fights go on for years. And really, the lawyers are the ones that get rich then. Um, and I'm not saying I don't like to see that. Even though I make my living from probate litigation, trust litigation, I like to see everyone get along if that's possible. But when
So the point
someone
is, do it
gets
right
their
at the onset, have
e-
it tight, and pay whatever
spend
fees associated with it to avoid
right,
more expense down the line, right?
right. And as your previous guest said last week, spend a little more now. It will save you tons in the future. And by the way, one other thing where people are very reticent to spend money is on corporate trustees. Um, yes, a bank trust company or private professional fiduciary, they may charge between 1% and 1.5% when they take over. That's per year, but they
Of the
follow
overall assets.
of the assets of the trust they're managing, but they follow the trust. They don't take sides. They don't get involved in petty because they don't have any baggage, emotional baggage. They're independent third parties, but they follow what the trust says, and they don't die, go on vacation. They're there to manage the trust, and that can be the best bargain of all. But so many
Makes
people
sense.
don't, when they don't like the idea. They think that one of their children would be better able to handle it, but they don't realize all the permutations and combinations of events that can happen where having one child dole out the money to the others can create World War III.
Fair enough. And we always want to prevent World War III.
Right.
So, Keith, as we round out the hour, I'm curious as to how a prospective client could prepare for a meeting where they're going to discuss asset protection and putting a plan together. What does an ideal prospective client look like when they walk into your office?
Well, first of all, one who, for asset protection, the ideal client is someone who has no pending or threatened litigation.
So,
Okay.
as soon as you're served, it's
No,
too late.
no. As soon as an event has occurred, even if you haven't been, but it's imminent. You know it's coming because, let's say in the physician case, cut off the wrong arm. Yeah, you haven't been served yet. Or in the automobile thing, you already killed someone with your car, but you haven't gotten into the lawsuit yet. But you know that it's coming, and your policy limits aren't going to cover it. The ideal client is someone, or prospect is someone who where the seas are calm. There's no foreseeable creditor, and when we set up a structure that makes business sense, when there's no threatened or pending litigation, that is where a solid asset protection structure can be put into place. And again, these do not involve hiding taxes, secreting assets, lying, anything like that. If the asset protection structure doesn't stand on its own because it's set up properly, then I want no part of it. And it will ultimately fail. It will be doomed to fail if it's based on any of those things: cheating, evading, secreting. You know what I'm talking about.
Well, Keith, thank you so much. This is the hour. It's been extremely eye-opening for me and a lot of the people on here. I don't think we've had a webcast with so many comments.
I'll be here all night, by the way. I'm here all
I would love to have you.
I'm here all week.
Hour. But how can people get in contact with you?
949-622-5450. 949-622-5450. That's my number. My office is in Irvine near the airport, but I serve all of Southern California. And I'm also licensed in 3 states, New York, Florida, as well as California. And email is Keith, that's Keith, at OC, like Orange County, trustlawyer.com.
All right. Well, Keith, thank you so much. Appreciate it. Hopefully we'll have you on a future live stream.
Okay.
And all the best.
Thank you.
All right. Thanks, Keith.
Bye.
All right, guys. You've heard it here. So many insights about asset protection, about limited liability, and the fact that you can't wait until you get sued to manage this. You got to get on top of it now. This is the time. So if you have assets to protect, businesses to protect, real estate, retirement accounts, rental properties, you got to have a solid asset protection plan in place now so that when stuff hits the fan, you're going to be all set with a solid plan in place. If you guys enjoyed this video, definitely subscribe to the channel. There's going to be more great content coming. The Efros Financial Power Hour live stream happens every Wednesday at 7 Pacific, 10 o'clock Eastern. And I'd love for you guys to come back because we're going to have amazing guests and there's going to be a wealth of knowledge coming. If you want to help this channel out, if you're still watching, hit that like button for me. Subscribe to the channel. Would you just gently caress that like button? And what would really help is if you guys share this video. Very simple. You grab the YouTube link, you throw it on your LinkedIn. Grab the YouTube link, you throw it on your Facebook. It'll do the rest of the work. There's a magical thumbnail that comes up and all that good stuff. That's going to help tremendously to make sure that we can keep putting this content out for you guys. And with that, hopefully this was helpful. Thanks for watching.